Welcome to this explainer. Today, we're taking absolute command of the 5-unit syllabus of Contract Law 2, and we're doing it by exploring the dynamic, real-world legal life cycle of commerce. We aren't just reading dry statutes here. We're going to break down the actual rules of the game that dictate how businesses survive, how they thrive, and how they sometimes completely collapse.
Here's our roadmap for today. We've got 4 main stops: risk protection, the contract of agency, sale of goods and property passing, and finally, the contract of partnership. We're building your legal arsenal step by step. Let's get right into it.
All right, Phase 1, Risk Protection. We'll be looking at indemnity, guarantee, bailment, and pledge. Because, let's face it, before any business can aggressively go out and conquer a market, it has to construct an ironclad legal shield to protect its downside.
Look at the difference here. A contract of indemnity, under Section 124, is basically a straight two-party shield against a promisor's own conduct. It's just a simple, hey, I'll cover your losses promise. But a guarantee, under Section 126, that is a much heavier piece of armor. It brings in a third party, the surety, to backstop a default. So you've got 3 parties and 3 totally distinct legal relationships.
And if you happen to be that surety, this right here is the absolute most powerful weapon you have: subrogation. Under Section 140, when you actually pay up the debt as a guarantor, you execute the power of subrogation. You literally step right into the creditor's shoes. You acquire all of their rights, meaning you can aggressively hunt down that principal debtor and get back exactly what you're owed. You don't just pay and walk away, you literally become the new creditor.
But what happens when the game changes? Think about this high-stakes scenario. You guaranteed a loan under very specific terms. Can a bank just unilaterally change those rules without even telling you, the guarantor?
To answer that, we've got to break down the landmark case of State Bank of India v. Indo-Export Registered. The facts are wild. The bank actually extended the repayment time for the principal debtor, but they totally failed to get the surety's consent. I mean, it seems harmless enough, right? Wrong. The Supreme Court dropped the gavel hard on this. Under Section 133, changing the risk profile in any way, even just by giving some extra time, without consent is a variance in terms. The conclusion? It triggers a classic Section 133 discharge of the surety. So the bank's little well-intentioned concession ended up costing them their entire guarantee. It perfectly illustrates why strict adherence to the original contract is simply non-negotiable.
Moving on to Phase 2, the contract of agency, or operating through representatives. Because naturally, businesses have to scale. You can't be everywhere at once, right? So you scale by employing agents under Sections 182 to 238 to act on your behalf and bind you to third parties.
But listen, with that immense power comes immense legal responsibility. Look at these statutory duties. If you are acting as an agent, your duties are absolute. You've got to follow instructions under Section 211, exercise actual skill and diligence under 212, and you can absolutely never secretly deal on your own account under 215. If you deviate from those strict instructions, you personally absorb the financial impact of any loss. You are playing with someone else's money, and the law definitely does not forgive negligence.
Okay, so the agent is bound pretty tightly, but what about the principal? What happens if the principal tries to pull the plug early and fire an agent who is sitting there waiting on a massive commission from an impending sale?
Let's look at the landmark case Pana Law Jankidas v. Mohan Law. The principal actually tried to revoke the agency right before the sale completed, specifically to avoid paying the agent's commission out of the proceeds. Well, the Supreme Court stepped in and applied Section 202 of the Indian Contract Act. Because the agent already had a financial interest in the subject matter, meaning their commission was tied directly to the property, the court ruled this an agency coupled with interest. The ultimate conclusion? It's completely irrevocable. The revocation was struck down, and the agent's hard-earned commission was firmly protected.
All right, Phase 3, sale of goods and property passing. This right here is the actual battlefield of commerce. It's where goods change hands and, frankly, where massive liabilities are born.
The absolute crucial point to understand here is timing. A sale under Section 4 transfers the property and the goods instantly. So if the buyer defaults, you can aggressively sue for the actual price of the goods. An agreement to sell, on the other hand, means the transfer is happening in the future, or it's subject to certain conditions. If a deal collapses at that stage, your remedy is strictly limited to suing for damages. You can't sue for the full price. Knowing exactly which contract you hold dictates your entire legal strategy when things go south.
And the second you become a buyer, you're immediately slammed with this ancient, ruthless doctrine, caveat emptor.
let the buyer beware. It's essentially an invisible shield for the seller, and it puts the entire burden of inspection squarely on you. The seller doesn't have to hold your hand and point out the flaws. It is 100% your job to examine those goods.
But come on, there has to be a limit, right? What happens when a defect is completely latent? I mean, totally hidden deep within the product, and it ends up causing serious physical harm to the buyer.
To crack this one open, we look at the famous itchy underwear case, Grant v. Australian Knitting Mills, Ltd. Dr. Grant bought some woolen underwear that secretly contained excess sulfite, which gave him severe dermatitis. Obviously, he couldn't have seen it during a normal inspection. The Privy Council totally shattered the caveat emptor defense here by applying Section 16(2). They ruled that goods sold in the course of business carry an implied condition of merchantable quality. The conclusion was absolutely devastating for the defense. Both the retailer and the manufacturer were held fully liable. A hidden defect that makes goods unfit breaches this condition, no matter how carefully you inspect it.
Which brings us to exactly when ownership transfers. This timeline is critical, folks, because in commercial law, risk follows property. Under Section 26, the exact second property passes on this timeline, whether it's when the contract is made for specific goods or when unascertained goods in bulk are finally unconditionally appropriated, the risk of destruction becomes the buyer's absolute nightmare. Even if you haven't taken physical delivery yet, if that warehouse burns to the ground, it is your loss.
And that leads right into the foundational bedrock of all property law, nemo dat quod non habet. No one can give what he does not have. Section 27 dictates that a seller who holds no title, like a thief, can never pass good title to an innocent buyer, period. The true owner always wins.
But, the law is actually pretty pragmatic. If nemo dat was absolute, commercial trade would freeze up entirely. Nobody would trust anything. So the Act allows for these rapid-fire exceptions, a sale by a mercantile agent in possession, or a co-owner, or someone holding goods under a voidable contract before it's actually voided. In these specific high-velocity scenarios, a non-owner can actually pass perfect title. Why? Simply to protect innocent buyers and keep the gears of commerce moving.
Let's flip the perspective for a second. What if you sell the goods, pass the title, and then, boom, the buyer suddenly goes insolvent before they even pay you? Well, as an unpaid seller, you can deploy this incredibly powerful statutory arsenal against the goods themselves. You exercise your right of lien to physically retain the goods. If they're already on a truck, you execute stoppage in transit. And ultimately, under Section 54, you trigger your right of resale to liquidate the goods and get your money back. It's a built-in tactical retrieval system. All right, we made it to the final section, the contract of partnership, teaming up for enterprise. Let's see what happens when individuals combine forces under the Indian Partnership Act of 1932.
Look at this table. While an unregistered partnership is incredibly easy to form, basically just an agreement to share profits, it comes with a frankly terrifying trade-off compared to a registered company. In a partnership, you don't have a separate legal entity. That means you take on unlimited personal liability. If the business goes under, your personal assets, your house, your life savings, they all go down with it.
And since you're all essentially agents for one another, the actions of just one partner bind everyone else. So consider this monumental borrowing dispute in Malla March & Co., the Court of Wards. Does a partner's implied authority to conduct business automatically give them the power to go out and take massive loans in the firm's name?
In that case, the managing partners borrowed heavy funds on behalf of the firm without telling everyone. The Privy Council laid down a crystal-clear rule under Section 19. If it's a trading firm, borrowing money is considered an incidental, implied authority. It's just expected in the ordinary course of business. The conclusion? The entire trading firm was legally bound by that massive debt. Every single partner was on the hook for the loan, regardless of whether they personally signed the paperwork or not.
Which brings us to the most dangerous and yet fascinating reality of contract law too. Section 6 tells us that profit sharing isn't actually the true test of a partnership. Mutual agency is. Mutual agency means anyone acting on behalf of the business can bind everyone else to unlimited liability. So, as you go out there and build your commercial empire, you've always got to ask yourself, who holds the power to bankrupt your enterprise today?